Next, we have the presentation of the Lifetime Achievement Award to Steve Langer. The text of this award reads as follows. This award honors those individuals who have dedicated a professional lifetime to upholding both the letter and the intent of Article 1, Sections 12 and 23 of the Indiana Constitution. Section 12, of course, is all courts shall be open for all of us, and Section 23 is the Equal Protection Clause. Steve has made a lifetime of doing this. I remember many years ago meeting Steve for the first time and wondering, who is this guy from the region who just gets stuff done? And when he was ITLA president years ago, he led our organization with great leadership, great ideas, and it hasn't stopped. As president this year, I get to get calls from Steve every once in a while, which are my favorite phone calls.
Hey, Bob, it's Steve Langer. I have no life. Can you help me find that bill?
This is a Saturday night, he's calling me. So, anyway, he hasn't stopped. He's still got his hands in the mix, and I can't think of a better honoree. And I'm excited to hear what Steve has to say, so I'd like to welcome Steve to the podium. Steve, Steve told me I did it wrong, so which I did.
We actually had this plan so that you all would stand up twice for Steve, because you know, him and his ego.
My bad.
American abolitionist Henry Ward Beecher said, "A law is valuable not because it is a law, but because there is right in it." Our lifetime honoree works every day to fight for what is right. He has been instrumental in developing and shaping laws so that we live in a more just society. Whether as a trial, an appellate attorney, or an advocate before the legislature, Stephen L. Langer brings value to his clients and to the citizens of Indiana by relentlessly pursuing what is right. Now, if you were to ask Steve, he would probably tell you that that's enough. There's no reason for me to go on about him. Steve is one of the most humble people I know, which makes it a real honor to be able to stand before you and brag about him for a few minutes today. Steve is a founding partner at the Valparaiso office of Langer & Langer, where he focuses on medical malpractice and personal injury. Over the last 46 years, Steve has not only worked diligently for his clients, but has volunteered hundreds and hundreds of hours to our organization. In addition to serving numerous years on the executive committee, Steve regularly speaks at seminars, frequently serves as amicus counsel, chaired the amicus committee for many years, served as president of ITLA, is a past president of ITLA's College of Fellows, contributes on the legislative front, and offers guidance to other members. Steve is a prolific amicus brief writer. Notably, in the case of Boko versus Anonymous, Steve, along with his daughter Sarah, successfully argued that a trial court does not have the authority to act as a gatekeeper for what a party can include in its medical review panel submission. Additionally, when med-mal fee agreements came under scrutiny during the disciplinary case Henry Stevens, Steve was one of the lawyers who took the lead in fighting to preserve the status quo. Ultimately, the Indiana Supreme Court held that the fees in that case were reasonable and tacitly approved the fee agreement Indiana medical malpractice attorneys had been using for years. Steve has also contributed significantly on the legislative side of things. He was instrumental during the 2016 legislative hearings, which resulted in an increase in the medical malpractice cap on damages. He also successfully lobbied for the statute which gave a cause of action for the wrongful death of a viable fetus. While Steve is known statewide for his work in shaping laws through the judicial system and with the legislature, his clients admire and appreciate Steve for how he has personally impacted and changed their lives. As one client explained, he leaves no stone unturned, and while working with him, you have no doubt that he is going to fully dedicate himself to your case. I am eternally grateful for his perseverance and support throughout the legal process, and I can't thank him enough for helping me get justice for my mother. Steve is not only a dedicated trial attorney, he is a dedicated and devoted husband and father. If you ask Steve how things are going, he is unlikely to tell you about any of the myriad of cases he is working on or the undoubted success that he has recently achieved. What you will hear about is the latest successes obtained by his children, Rob and Sarah, who we are fortunate to also have as ITLA members. Or you may hear about his lovely wife, Diana, who along with Steve was awarded the Consumer Advocate of the Year Award for their advocacy in supporting individuals with dyslexia. Now, before I wrap things up, I will confess that in preparing for this event, I did what all good lawyers do and asked ChatGPT about Steve. While I personally have a love-hate relationship with ChatGPT, some of the comments that AI said about Steve were so accurate that I feel compelled to share. Langer is considered a top-tier Indiana plaintiff's trial lawyer, especially in medical malpractice. He's deeply embedded in the trial lawyer community, both through leadership roles and legislative involvement. He has a long track record of receiving recognition and working on complex cases. He has a reputation for being very serious and methodical. Some attorneys joke that he's the type who will out-prepare you so thoroughly it feels unfair. What really defines Steve is his preparation, his precision, and his unwavering commitment to his clients. He's known as someone who doesn't rely on theatrics. He relies on doing the work, mastering the details, and presenting a case with clarity and credibility. He is the kind of lawyer who makes everyone else in the room raise their game. It is my honor and privilege to introduce the 2026 Lifetime Achievement Honoree, an attorney who works every day to do what is right, Mr. Stephen L. Langer.
Hold on, I'll give a speech after my photo. Thank you. Thanks, Bob.
You're welcome.
Thank you all for coming. Emily, where'd you go? Thank you for the introduction. A lot of it seems, came from ChatGPT. I'd also like to thank Dan Ladendorf, Mark Ladendorf, Dan Pfeiffer, Jerry Garrow, and Betsy Green for nominating me for this award. My mother and Mickey Wilson have always told me, it's okay to brag, just keep it to yourself. And I sort of have done that because there's no point in self-promoting, at least the way I look at it. I'm honored and humbled to receive this award. When I first got the call from Jason, it took a while to understand what it is that I'm receiving. But then I look back at all the work that I did with others, and many, many others led to this. And now, when I talk a little bit about ITLA, you'll understand what I'm saying. But before I do this, I want to introduce some people. Honey, you don't have to stand. That's my wife, Diana. Wave. Next are my children, Rob and Sarah. I want to digress for a minute because I was thinking back, as sometimes you do, and I was saying, God, let me go over, maybe I'll talk about some of the jury trials I did or some of this. And then I looked back, and Holly Ruth reminded me, look back at what my best accomplishment has been in the law, and it has been the privilege of having my children work with me. I cannot tell them how much it means to me. But I also have my daughter-in-law, Jordan, say aye. I'm going to be a grandfather on October 1 to a boy, no. Probably around 8:48 a.m. Not sure yet, but that's about what it is. And my daughter's fiance, Stevie, say hi. My assistant, Shannon, my real boss at work, say hi, Shannon. She has stuck in my corner and helped me through a lot of tough times and is responsible for some of the results that I've gotten. And next is Holly, Danielle, Heather, and John. I have been blessed throughout my entire legal career of being associated with people a lot smarter than me. And they are like the best team members and my son and my daughter that they can have. Rob and Sarah and Holly and Danielle and Heather and John, they're all much smarter than me. And if you have a legal question, ask them, don't ask me. And then Mickey Wilson. Mickey was the executive director of ITLA from 1978 to December 2020. Something like that. Okay. And she has been with me through much of my journey with ITLA, through my role in the executive committee, through my role as president of the Indiana Trial Lawyers Association. So I'm going to be talking about some bills and some things ITLA has done, but much of the credit goes to the ITLA staff. Very little goes to me. The text of the Lifetime Achievement Award says, the award honors those individuals who have dedicated a professional life to upholding both the letter and intent of Article 1, Section 12, and 23 of the Constitution. Court shall be open for redress, and everybody should be treated equally under the law. So what I'm going to talk about now for a few minutes is how ITLA has implemented this mandate and how ITLA, and my small observation of ITLA as it went through some of these cases of what they've done, in the hopes that all of you, when you leave here today, will appreciate what ITLA has done for all of us to make our legal careers successful and give individuals the right to go to a courtroom and have their cases heard. So first, Bolin versus Winghart, and Emily touched on that. That was a March 11, 2002 Supreme Court decision. There, it was a 14-week-old baby who was in a car crash, and the baby died in the crash. So the case went up to the Indiana Supreme Court. The Indiana Supreme Court interpreted the wrongful death statute for children to mean the child has to be born alive. If the child is not born alive, you have remedies. They said negligent infliction of emotional distress, but you don't have a wrongful death action. ITLA undertook a course of lobbying from 2002 to 2009 until the Bolin Amendment was passed into law, where the Indiana Child Wrongful Death Statute incorporated Title 16 in the definition of viability, so that a child or baby capable of living outside the womb that is viable constitutes a wrongful death. Emily also touched on In re Stevens, a 2006 decision in which Dan Stevens, an attorney from the region, now deceased, used a sliding scale fee agreement that went up before the disciplinary commission. The Supreme Court, in a scathing opinion, said that such fee agreements are not recognized, it's wrong, and the next time a lawyer does something, they're going to be suspended. Well, virtually every med-mal lawyer, including me, used sliding scale fee agreements. And ITLA got together, I just happened to be there when it came through, a group of people. We put together a committee. We hired a lawyer called Carl Mulvaney, and since we couldn't get it done legislatively, we petitioned the Supreme Court to rehear In re Stevens. The Supreme Court did rehear In re Stevens, and a year later, in 2007, approved sliding scale fee agreements. The takeaway message from this is it gave our clients access to courts where lawyers could be fairly compensated. In 2017, after years of lobbying, the cap from medical malpractice cases was $500,000, then $750,000, then $1,250,000. We were successful in almost virtually controlled Republican legislature to get the med-mal caps increased up to $1.8 million where they are now. This action helps all of us get better justice for our clients. In addition, those of us who do medical malpractice work know that we've had trouble for years getting discovery, getting cases through the panel, getting folks to do things. In 2017, ITLA was successful in getting an amendment to the Malpractice Act, which is now in the preface, that sets forth the public policy in the state of Indiana that you're supposed to get these cases through the panel process quickly, efficiently, and courts have the power to enforce these rules. So that's just some of what ITLA does. But there's another component to this. Tom Mangus mentioned it in his speech today or in his presentation about amicus. I want to share with you briefly some of the amicus work that I've had the privilege of being involved in ITLA. McCarty versus Sanders in 2004. There was the Patients' Compensation Fund was saying, hey, you got one occurrence of malpractice, 2 victims, so you got to get 2 payouts to get to the fund. Well, that's unfair. So we took that up. I wrote was involved in writing the amicus brief on that case, and the Court of Appeals said, no, one occurrence, you can get to the fund with one healthcare provider payment. So, for example, a mom is injured, a baby is injured, or twins are injured in delivery, one occurrence, you can get multiple caps. Then we thought that the Malpractice Act gave the plaintiff's lawyers an easy road, so to speak, once you got to the Patient's Compensation Fund, and that the statute clearly says that liability is established, negligence and damages when you go to the fund. Well, things that seem black and white to everyone didn't seem that way to the PCF. So they started appealing these cases. One was Adderholt versus Robertson, and in that case, the settlement agreement was silent as to what the theory of recovery was. The Court of Appeals said, well, since it's not delineated in the settlement agreement, the PCF can challenge the theory of recovery. It's really challenging damages, not liability. Then in the Herbst decision, which went to the Supreme Court that I was involved in that case, it was the pre-existing risk of harm. The Supreme Court entered an opinion that said the PCF is free to contest the theory of liability and pre-existing harm even after a jury verdict. So we made a petition for rehearing to the Indiana Supreme Court. Those are rarely granted. The Supreme Court granted it and set it aside. Then there was the Jim McDonald case, right? You had Everhart, right, Jim? Yeah, I did the amicus brief on that. And in that case, the PCF was trying to say that if your chance of recovery is greater than 50%, but less than 100, they should still be able to get a set-off for that amount of money. Thanks to Jim's unbelievable lawyering, even if they applied that formula in his case, the verdict or the judgment would have been the same, but the court declined to go down that road. Finally, there was Robertson versus BO, and in that case that I was involved in, the Supreme Court directly addressed negligence and the theory of recovery in PCF cases, and the court unequivocally held that liability is established, and there's only certain things that the PCF can do. One is, say, the damages are not compensable under Indiana law. We all knew that anyway. Then there's Clark versus Mateer. It was mentioned that was a medical malpractice case that was tried twice. That case dealt with challenges for cause, that we were involved in the amicus and we were successful in the Supreme Court making the law that if someone says, if they're unequivocal, a juror is unequivocal in what they're saying, you have a right to interrogate that juror to say why it is you don't believe in pain and suffering and why it is you don't want to sit on a jury. The trial judge cannot unilaterally just say, no more questions, you have to use a peremptory challenge, not a challenge for cause. Arundel versus American Imaging, that was in the Supreme Court 2022 decision, that expanded SWORD to non-hospital medical entities. So ITLA has done tremendous work in making courts available to all of our clients and providing equal justice for everybody. Since 2012, ITLA has authored 92 amicus briefs. Just think about the work and the contributions of all of its members. I cannot tell you the number of legislative bills that have been killed. I'm about done, but before I sit down, I want to talk about our listservs. They are valuable, they're a good way of communicating, and I know some people have said, Steve, I don't want to post something on there because what if I'm wrong? Who cares? The idea, no one says, oh, that's stupid. You look at the idea, physicians do it all the time. They publish peer-reviewed articles, they throw it out there to see if it's good or bad to improve. So if you have something to say, the comments are welcome. The sharing of information helps everybody. And I think special kudos go to Jeff Cook, because it was his idea to put this together and start this in motion. So before I sit down, I want you all to know that my intent in coming here today was not to talk about me, but to talk about the future and how important ITLA is to our future. And by going through these few examples, I hope we all understand what working together as a team can do to keep courts open for the public and to treat everybody equally. I know Fred Schultz gave a comment about LawPac today. It wasn't on my agenda, but I think what I understand, I'm sort of out in the fields right now since I'm done being on the executive committee and everything, that we're going to have a whole bunch of challenges next year, one of which is to put like $1 million cap on pain and suffering in every single tort case. So we have a great team at ITLA. Jason and Sarah and Amanda, Jen, everybody. I think we can work together and we can give them a run for the money. And at the end of the day, we faced a lot of challenges and we've come out on top. So I just want to thank you all for coming today. I cannot tell you how much I'm humbled. But thank you.
Well, congratulations again, Chase, Steve, and our new officers and directors. Tonight, or after the afternoon session, I would like to remind everyone there will be a reception honoring Steve Langer at the conclusion of today's program at 5:15 at Low Millers. So please come and enjoy. It's all on Steve tonight. And now we are going to adjourn to the seminar. First up will be Brad Catlin, who's going to speak on the new pathway to case management. So sounds exciting. Thank you, everybody.